My name is Pamela Coveney. I'm one of the attorneys at the Disability Law Center, and I want to talk to you a little bit about what some of your options are when you and a school disagree about your students' special education services. I know that can be a very, very frustrating process, and lots of times when you're at a team meeting, you can feel very outnumbered and overwhelmed. And I don't know that I can really keep you from feeling that way, but what I want to do is just to offer you some strategies to pursue when that happens. It is very important to remember that even though you're not the final decision maker at an IEP team, you are entitled to participate, you're entitled to have the team be conducted in your native language or to have a translator there, and you are entitled to be heard. Once you get to the team meeting level and things don't work out the way you want them to and you disagree with the team, it's very, very important to make your concerns known to the members of the team. And usually when we talk to parents and they tell us that they have a complaint, my very first question is, did you tell anybody? And they normally say yes. And then I say, did you tell them verbally or did you write them a letter? And in almost all instances, somebody will tell me that they spoke to somebody in the hallway about their concern or complaint, and they don't remember the person's name, and they never wrote a letter. So the very first rule of special education law is that if you don't write it down, you can assume that for all intents and purposes it did not happen. It is essential to communicate in writing with the members of the IEP team and to make your concerns clearly understood, that you disagree about services or you disagree about placement or whatever the issue happens to be. If that doesn't work, it simply is time to move on. And we often find when there are special education disputes that parents just stay at this level too long and they go back and forth with the members of the IEP team thinking that they're going to get a different result. It is time, once you've communicated your concerns and they're not resolved to your satisfaction, to consider the next procedural step. Now, the ultimate endpoint is a hearing with the Bureau of Special Education Appeals, and that's usually the final resting place, so to speak, for a special education dispute. Some matters actually get to federal court, but they are by far the exception. Usually the special education dispute stops after a Bureau of Special Education Appeals hearing. But before you even get there, there are lots of steps that you can consider taking. The first of which is to request mediation. Now, mediation is a voluntary process, and just because you ask the school to participate in mediation, they don't have to do it. They can decline. But it's a useful process if the school will agree, because first of all, you get a third person in the room to hear both sides' concerns. The third person works for the Department of Elementary and Secondary Education. They're well versed in special education law, and sometimes it's just very useful to have a cool head in the room who isn't affiliated with either party. And in fact, mediations do result in some sort of agreement in slightly over half the cases, so it's a good first step to consider. Let's assume, however, that you've asked for mediation and the school has declined, and you then have to figure out what you want to do. And at that point, it's probably a good idea to talk to an attorney if you haven't already done so, because your next option is to file a hearing request at the Bureau of Special Education Appeals. And to do that, it's not essential. It's in no way required that you have a lawyer, but it's a good idea because it's a somewhat multi-layered process. There are lots of procedural rules to follow because you're essentially now suing the school district. And when you sue somebody, it's a good idea to have a lawyer. When you get to that point, after you have filed a hearing request, the law entitles you as a parent to what's known as a resolution session. And unlike mediation, this is not voluntary on the school's part if you request it. If you ask for it, the school must participate. And again, even if it doesn't resolve the problem, it gets both sides in a room. Usually they're represented by counsel at that point. And even if it doesn't fix the problem, it gives you an opportunity to hear the school side of the dispute and to get some idea of the strengths and weaknesses of your own case. If by chance the resolution session does not resolve the problem, the last step to consider taking before you actually go to a hearing is to request a settlement conference. And that's very much like mediation in many ways, but there are at least 3 important differences. The first is that it's only available to you after you have filed a hearing request. The second is that in order to get a settlement conference, the hearing officer who is assigned to your case must approve. And third, each side has to be represented by counsel in order for you to be eligible to have a settlement conference. In general, they're conducted by a person who now serves as the head of the Bureau of Special Education Appeals, who served as a hearing officer herself for many years. So she's got a very, very good knowledge of special education law and also of the individual hearing officers. And the value of this process is that she reviews selected documents in advance from either side. She meets with both sides as a group, and then she meets with each side individually to share her perception of the relative strengths and weaknesses of your case. This process has resulted in resolution in probably well over 90% of the cases where it's been used, because as a practical matter, if the head of the whole Bureau of Special Education Appeals tells you that you've not got a strong case, you or the school district, whoever is getting that unfortunate news, is not really likely to want to go forward. So it's a very, very useful process to consider. The final resting place, so to speak, of special education disputes is at the actual Bureau of Special Education Appeals itself. And this is really, for all intents and purposes, a trial. It's an administrative hearing. So each side has to first participate in an informal telephone conference just to sort of help the hearing officer understand what the case is about. Then there's a rather lengthy process of exchanging documents and identifying the witnesses that you intend to call. Then there's the actual hearing itself. And in my experience, they'll last anywhere between 1 to 4 days. Each side gets to put on witnesses and to present expert testimony. And then there are closing arguments at the end. That might occur right on the date of the hearing, or the parties might request the opportunity to write a written closing argument after the hearing, at which point the record, so to speak, then closes and the hearing officer will issue a written decision. I want to underscore that going to the Bureau of Special Education Appeals should be a last resort. It is really something that you should only consider after you've tried, at least, to take all of the other steps that I've recommended. In fiscal year 2012, there were well over 600 hearing requests, and only about 52 of them resulted in written decisions. And that should tell you a lot, that basically most of those matters settled in between the time that somebody actually filed the hearing request and the time that there was a settlement. 52 decisions resulted out of the whole process. It is very important to remember when you get to this step that it is extremely important that you consult a lawyer to get some idea of the relative strengths and weaknesses of your case. The other thing that is very difficult sometimes for a lot of people to understand is that the law does not entitle you to everything that you think your student needs. And that's why getting the input of a lawyer is really critical at this stage, to get some sense of whether the current state of the law, both in terms of statutes and regulations and in terms of the way courts have interpreted those laws, gives you what it is that you are requesting. We'd like very much for you to consider the Disability Law Center as a resource when you're considering a special education dispute, we have a lot of resources to offer and a lot of advice that we can share, and we hope that you'll think about giving us an opportunity to assist you. Thanks very much for listening.